Under the Fourth Amendment of the Constitution and under Georgia, she does have the right to be free from illegal stops in the state. Again, has the burden to establish that the stop was based on reasonable suspicion. So first of all, the state is not citing any case or legal principle other than just a vague reference to the collective knowledge doctrine. And if it is, as the state suggests, then there would be no need for the hearsay rule in criminal prosecutions.
A limitation of the collective knowledge doctrine is that the officer who is presenting the evidence and testimony, it cannot use collective knowledge doctrine to establish probable cause, reason for the arrest.
In Clayton County, Georgia, a motion to suppress hearing was called in the DUI case of Miss Thomas before Judge Tammi Longward. The officer who conducted the field sobriety testing and made the arrest was not the same officer who initiated the stop. That single fact became the foundation of a Fourth Amendment challenge built entirely around one legal question when the only officer on the stand learned everything he knew from another officer who never testified. Does that testimony cross into hearsay? And if so, can it still establish the reasonable suspicion required for a lawful stop? The state had an answer. The defense had a different one, and Judge Longward was about to decide which legal principle controlled the outcome.
Raise your right hand for me, sir. You solemnly swear or affirm any testimony you give in this matter will be true?
I do.
All right. Your witness, Ms. Adams.
Good afternoon. Could you please state your name for the record?
Officer Nathan Proctor.
Officer Proctor, where are you employed?
City of Riverdale Police.
And how long have you been employed with the City of Riverdale Police Department?
Just shy of 5 years.
What's your current role at the Riverdale Police Department?
Police Officer 2, Road Patrol.
And what are some of your duties?
Currently, right now, I'm assigned to the traffic unit, so responding to calls for service, traffic accidents, and general patrol, things of that nature.
Are you post-certified?
I am.
And how long have you been post-certified?
The same amount I've worked there, so just under 5 years.
On a day of an incident, were you on duty?
Yes.
And did you come in contact with the defendant?
I did.
And how did you come?
I'm going to object to the extent that it calls for hearsay.
How he came in contact calls for a hearsay?
Well, if he's going to testify as to what another officer reported to him or that he received a call that stated certain information, then the question would call for hearsay. So
Well, since I haven't heard it yet, let me state that let him answer the question.
You're right.
That is correct, Your Honor. I was called by another officer.
All right, Ms. Adams. I say hearsay would be anything that this officer was told by another officer that got him to the scene. Is there anything else? I'm just trying to give you a context for your questions.
As it relates to that hearsay objection, Your Honor, I would just like to for the court note that police can rely on based on the collective knowledge doctrine. If that allows law enforcement to rely on each other's collective knowledge, even if they don't have direct knowledge of all the facts. But so essentially, it's no different than being dispatched from a 911 officer or by a 911 operator, excuse me.
Hey, Mr. Lynch, collective knowledge doctrine.
Hearsay is not admissible to the extent that it is. It has no probative value. Obviously she can go on questioning this officer about this interaction and what he can testify from his personal knowledge. Of course that's the case. And I'm not quite sure the argument the state might be making about collective knowledge. I know that I will have a response at the end of this motion to any arguments about that.
All right. Go ahead, sir.
Officer Proctor?
Yes, ma'am.
Would you like for me to repeat that question for you?
How I came in contact with the defendant?
Yes, Jan. Yes, officer.
I received a phone call from a sheriff's deputy that was requesting another unit out in reference to a possible drunk driver.
And what was the next action that you took?
I drove over to the scene, which was up Riverdale Road and Valley Hill Road, and I met with the officer and spoke to him when I arrived here.
When you arrived on the scene, what was your role in the investigation?
I conducted field sobriety testing on the defendant.
When you arrived on the scene, did you make contact with the defendant?
I did.
Well, actually, I want to go back to when you mentioned that you first arrived into the scene and then you spoke with the officer that called for your assistance. When you arrived and spoke with that officer, what were you informed?
Objection, calls for hearsay.
Those call for hearsay.
Again, I just refer the court back to the collective knowledge doctrine, where officers are able to utilize each other's collective knowledge to conduct stops, to conduct searches, perform arrest, based on the information that's held by the collective of officers.
Judge, so first of all, the state is not citing any case or legal principle other than just a vague reference to the collective knowledge doctrine. And if it is, as the state suggests, then there would be no need for the hearsay rule in criminal prosecutions, because in fact, she's asking this officer for the statements made by another officer for the truth of the matter contained in those statements. That is hearsay. That is not admissible. And even if he were to answer it, his answers to those questions have no probative value and should not be taken by this court to have any probative value whatsoever as to the truth of the matters. Hearsay is not admissible in these proceedings, and the state is not referencing any law that would just imply that hearsay doesn't apply in criminal proceedings, as she suggests. We object as to hearsay.
Honor, I would like to state that this is not being.
So the limitation of the collective knowledge doctrine is that the officer who is presenting the evidence and testimony, it cannot use the collective knowledge doctrine to establish probable cause or the reason for the arrest. They have to have their own independent knowledge of those things, but they can be including dispatchers. They can rely on the information of other officers and dispatchers with respect to the investigation of the case. Mr. Lynch will go ahead and take your objection as an continuing objection, and that will be noted for the record. But for the continuation of this hearing, the court is going to accept the testimony of the officer based on the collective knowledge of those who were involved in the investigation and arrest. Go ahead, Ms. Adams.
Thank you, Your Honor. All right, Officer Proctor. So you arrived to the scene and you spoke with, and who was the first person that you spoke with?
The deputy that called for the assistance.
Okay. And when you spoke with him, what did he advise you?
He explained that he had stopped the vehicle because that it had he observed it leave its lane and then jerk back into the lane. He initiated the traffic stop, and when he walked up to the window to speak to the operator, that he smelled alcohol.
Mm-hmm. And at that point, did you make contact with the defendant?
I did.
And what observations did you make at that point?
I detected a slight odor of alcohol, and from outside of there, when I arrived, I basically went right into asking her if she would conduct field sobriety testing.
What was her response?
She agreed.
Did you conduct those standardized field sobriety testing?
I did.
And how did the defendant perform?
Well, I started by asking her some medical questions, such as any recent head trauma, if she normally wear glasses or eye contacts, things like that. And once I established that she would be eligible to take the test, I started with horizontal gaze nystagmus. I checked her eyes for equal tracking, pupil dilation, and from there I conducted the horizontal gaze nystagmus test. She showed 4 out of the 6 clues. From there, I went to one leg stand, where she was observed, instead of placing her foot in front of her, approximately 6 inches off the ground, she bent her knee back to have her foot behind her. And she was also observed putting her hands in her pockets, not keeping them at her side. And the walk and turn test, she missed some heel to toe steps and conducted an improper turn. And I'm going all by memory. I don't have report or the video right now.
And what did you administer those tests based on your training and experience?
I did.
Are you trained in standardized testing?
I am.
How long have you been trained in SFS in performing SFSTs?
So the standardized field sobriety testing was provided to me during the duration of the Basic Law Enforcement Training Center Academy with Clayton County. So it's at the time of graduation, so just under 5 years.
Is your certification or is your training in accordance, or the things that you've learned is that in accordance with the standards from the National Highway Traffic Safety Administration?
It is.
And based on your observations of the standardized field sobriety testing, what was your next step?
Once she conducted the tests, again, going straight from memory, I have nothing to refer to. It's been a couple of years. I read her Georgia's implied consent for 21 years of age or over.
At any point, did you ask the defendant to submit to a portable breath test?
Yes.
My apologies. Did the defendant agree to performing that test?
Yes.
And when she performed it, what did the test indicate?
I'm going to object at this point. This is not competent evidence based on this. This is not scientifically validated evidence. I believe that what's admissible is whether she's positive for alcohol or not.
Well, he hasn't given a number, so I'm gonna assume that he's testified enough to know he can't give a number.
I just the phrasing of the question, Judge, but that's what I'm
Okay,
asking.
go ahead.
The portable breath test did confirm the presence of alcohol.
And when you read the defendant implied consent, did you, and you, just to confirm, you read the implied consent for suspects over 21 or over?
Yes,
Did you read it in its entirety?
I did.
Did you read it verbatim?
Yes.
What sample did you request?
Blood.
Okay, but I'd like to mark this as State's Exhibit 1.
We'll stipulate that it's admissible.
All right, so stipulation to the implied consent card. Go ahead.
Your Honor, I move to admit the implied consent card as an exhibit.
Yes, it's admitted as a by stipulation.
Okay. I'm going to read the implied consent notice for suspects age 21 or older. The state of Georgia has conditioned your privilege to drive upon the highways of this state upon your submission to state-administered chemical test of your blood, breath, urine, or other bodily substances for the purposes of determining if you are under the influence of alcohol or drugs. If you refuse this testing, your Georgia's driver's license or privilege to drive on the highways of this state will be suspended for a minimum period of 1 year. Your refusal to submit to blood or urine testing may be offered into evidence against you at trial. If you submit to testing and the results indicate an alcohol concentration of 0.08 grams or more, your Georgia driver's license or privilege to drive on the highways of this state may be suspended for a minimum period of 1 year. After first submitting to the requested state test, you are entitled to additional chemical tests of your blood, breath, urine, or other bodily substances at your own expense and from qualified personnel of your own choosing. Will you submit to the state-administered chemical test of your blood? Is that what you read?
Yes.
Did, when you read that implied consent notice to the defendant, what was the response?
He agreed to provide a blood sample.
So when you concluded your DUI investigation, what decision did you make?
On the scene, I effected an arrest and placed her in custody for DUI less safe.
And you placed her in custody based on a totality of circumstances, including your observations, the odor of alcohol, the defendant's performance on the standardized field sobriety testing, and anything
Right.
else?
No.
And when you, oh,
Again, I'm going from memory. I'm sorry. So I don't have anything available to me. The only other part of that would have been that when I did initially speak to her, she did tell me that she had consumed alcohol hours prior. But other than that, and outside of the field testing, no.
No further questions, Your Honor.
Cross-examination?
Thank you for being here, officer. I don't have any questions for you today.
Thank you, sir.
All right, does the state have another witness to present?
No further witnesses, Your Honor.
All right, does the defense have witnesses to present?
We will not be presenting evidence today, Judge.
All right, argument.
Judge, despite a vague allusion to the collective knowledge doctrine, absolutely no competent evidence has been presented to this court that can establish by a preponderance of the evidence that the stop of Ms. Thomas was justified based on reasonable suspicion. Hearsay has no probative value, Judge. My understanding, I'm doing a brief, as this motion is going on, understanding of the collective knowledge doctrine, but my understanding is that it may allow officers, well, it does not apply to overcome the hearsay ban and allow hearsay statements to establish reasonable suspicion for a stop without anything further, Judge. In this case, if so, the defendant has been denied the ability to cross-examine the officer who provided this information. So therefore, that would be a due process violation. There has been no testimony about any traffic violations, just that basically that was told to him by another officer. The state has the burden to present evidence, and they have the burden to present evidence that can convince you by a preponderance of the evidence that the stop on Ms. Thomas was lawful. If not, any evidence that was obtained after the stop is fruit of the poisonous tree and subject to the exclusionary rule. Here, Judge, I don't know how many times, Judge, there has been no evidence, none. A reference to the collective knowledge document does not establish a fact by a preponderance of the evidence. Hearsay has no probative value. Judge, we're asking that all evidence against Ms. Thomas be suppressed, as the state has failed to present any evidence whatsoever that is competent that this court can rely upon to establish that Ms. Thomas was indeed her rights under the Fourth Amendment, of the Constitution, and under Georgia. She has, and under, OCGA 17-5-30, she does have the right to be free from illegal stops in the state. Again, has the burden to establish that the stop was based on reasonable suspicion. They have failed to do that. Judge, I'm asking that all the evidence against, or any evidence that flowed from this illegal detention of Ms. Thomas, be suppressed.
Your Honor, the defense's argument focuses on the reasonableness of the stop, arguing that the officer that testified today did not personally observe a traffic violation and that the stop was unlawful, but that is not, I think that's a mischaracterization. Under the collective knowledge doctrine, which we referenced a couple of times today, reasonable suspicion can be based on the information that was relayed from another officer who actually did directly observe the violation. The officer that observed the violation did observe a traffic violation and then asked for subsequent officer communicated to other officers and asked for other officers to respond, which formed the basis for the testifying officer, the officer that testified today, to be on scene. The fact that he simply arrived later and the fact that he did not personally observe the violation, that more so goes to his role in the investigation, which is why he completed the subsequent DUI investigation, and it doesn't go as much to the legality of the stop itself. The stop was supported by reasonable suspicion, reasonable articulated suspicion based on the officer's own firsthand observations that he relayed to the unit. And therefore, I believe that witness's testimony does not negate the validity of the stop. And we do respectfully request that Your Honor deny the motion to suppress on that basis.
So we've talked a lot about the collective knowledge doctrine, but there are some limitations to it. So the purpose of the doctrine is to allow judges to hear the information necessary to make a decision that has a bearing prior to trial. So to make the decision based on whether information should be suppressed from the trial, the judge needs to hear it in a condensed version, and we're not putting on an entire trial. Thus, the collective knowledge doctrine. But the limitation is that in order to establish reasonable, articulable suspicion or probable cause, the officer speaking and relaying the collective knowledge has to have some basis independent of his information from other officers or other sources that would be the basis for reasonable, articulable suspicion or probable cause. In this case, as the testimony was given, this officer was told, was dispatched to the scene based on the request for assistance from a deputy. At the scene, he was told by the deputy that the deputy saw this individual leave their lane and jerk back into the lane, and that he smelled an odor of alcohol. What this officer then did was make contact with the individual, and on the basis of a slight odor of alcohol, and as we know, it is not illegal to imbibe alcoholic beverage and drive, based on a slight odor of alcohol, which absent the hearsay testimony or the collective knowledge testimony from the deputy, there would have been no way he could have appreciated the slight odor of alcohol such that it would have formed the basis of reasonable, articulable suspicion for the stop in this case. Anything after that is based on the hearsay and not on this officer's actual ability to determine that there was a reason for the stop and that there was probable cause for everything that followed. And so the court finds that this motion to suppress should be granted, not because this officer didn't do the job he was supposed to do, but because by the time that he came into the investigation, the parts that would have established the reasonable, articulable suspicion to stop and initiate the investigation had been done by another officer who is not here to testify, and his testimony is only entered into the record of the court based on the collective knowledge doctrine. And based on the collective knowledge doctrine, that testimony is insufficient to establish reasonable, articulable suspicion. It is hearsay without another officer having observed it and having testified to what he observed. So this court is going to grant the motion to suppress. Give me an order, Mr. Lynch.
Judge, you'll have it by the end of the day tomorrow.
All righty. All right. Do we have anything else?
Not to my knowledge.
Not that I'm aware
All right.
of.
I will be signing
Thank you, Judge.
a lot of stuff.
Thank you.
Judge Longward granted the motion to suppress, finding that the collective knowledge doctrine alone was insufficient to establish reasonable, articulable suspicion for the stop of Miss Thomas. The officer who actually observed the traffic violation never took the stand, and without that testimony, the state was left relying on hearsay that the court found legally inadequate. In Georgia, a granted motion to suppress means everything obtained after that unlawful stop is excluded entirely: field sobriety results, the blood sample, and the admission that she had consumed alcohol hours prior, all gone. The state came to that hearing without the one officer who could have made their case and paid the price for it. The burden was theirs, and they could not meet it. If you think the collective knowledge doctrine should have been enough, drop your verdict in the comments and subscribe for more cases like this one.